Meet Ken. He's not a doll. He's a real guy with a podcast, politics, and coffee. But when he tried to trademark the name Coffee with Ken, guess who objected? That's right, the makers of this guy. Because apparently the name Ken and the word coffee are just too close to their discontinued barista doll. And now Ken, the real one, is stuck in a trademark fight with Mattel over his own name. Welcome to True Court Tales, where courtroom chaos gets the spotlight it deserves. I talk about the bizarre, the unhinged, sometimes serious, and sometimes even heartwarming courtroom moments. If it happened in court, we're probably talking about it. All right, so today's case is Mattel versus Ken Bibberai, and I hope that I'm saying his name right. I watched part of his podcast, so hopefully I'm saying it correctly. I'm sorry if I'm not. But it's basically the Coffee with Ken podcast trademark battle. This case has not fully played out in court yet, but we're still going to talk about it because I think it's kind of crazy. So let's get to it. In May 2025, Mattel, the toy company behind Barbie, decided that they had a new threat to their empire. It was a podcast hosted by a real guy named Ken. So let's talk about Ken. Podcaster Ken. So Ken Bibberai is a DC real estate executive and former chairman of the Manhattan Chamber of Commerce. And yes, his name is actually Ken. The podcast Coffee with Ken is a political interview show. Think governors, CEOs, big talk over small coffee. It averages around 20,000 views per episode and has hosted live events with hundreds of attendees. So Ken filed a trademark application for Coffee with Ken. Well, Mattel got real mad. They filed a notice of opposition with the U.S. Patent and Trademark Trial and Appeal Board. They're the ones that handle the disputes over who gets to use what name. All right, so I'm going to try to break this down really quick so that you can understand what the basic process is for getting a trademark. I used to work for a trademark attorney, but I am by no means an expert in trademarks. But this is a general breakdown. So when someone files for a trademark like Coffee and Ken, it doesn't just get a rubber stamp. So a government examiner has to look it over first. And sometimes that even takes a while. If it passes that stage, it then gets published in something called the Official Gazette. I think the official name is Trademark Official Gazette. And that's basically a public listing of the proposed marks. So it's published like that before it's actually approved so that others can oppose it if they think it's too similar to their own name. But essentially, companies like Mattel have 30 days to say, hold on, we think this is going to confuse people and hurt our brand. And that's exactly what they did here. So in their opposition, they go on to talk about the history of the Ken doll and how super important and iconic it is. And I have to just read you a little bit of this opposition because I just thought some of it was really funny. This is part 7 of the opposition. It says, as a result of his near ubiquitous exposure, the Ken doll has become what GQ magazine labeled as an icon of American masculinity for multiple generations. So Mattel claimed that there's a high likelihood that a consumer will believe the podcast is somehow related to their Ken doll line. And you want to know what their evidence is? It's a discontinued doll from a few years back called the Ken Barista doll, who came complete with a man bun, an apron, and an espresso machine. In number 11 of the opposition, it says this. Since the launch of the Ken doll, Mattel has released numerous different Ken lines, including a Barista Ken doll. In line 20, it says, applicant's mark is highly similar to Mattel's Ken mark in appearance, sound, and commercial impression. Applicant's mark fully encompasses Mattel's Ken mark and merely adds the non-distinctive terms coffee with before the identical Ken mark. Moreover, as Mattel has offered numerous different Ken lines over the years, e.g. Barista Ken, it is highly likely that a consumer will believe that applicant's mark could be the name of or related to a Ken line and is affiliated with Mattel's Ken brand or otherwise sponsored by or associated with Mattel. That's right. Because this podcast had Ken in the title and involved coffee, Mattel argued that the public might think it was part of their doll line. Then in numbers 25 and 26, they said this. In view of the similarities of the parties' marks and the fame of Mattel's Ken mark, applicant's mark is likely to cause dilution by blurring the distinctive quality of the famous Ken mark. Mattel will be damaged by registration of applicant's mark in that it will dilute the distinctive qualities of Mattel's famous Ken mark. So Ken's response was great. He said, I don't think anyone expected a doll to interview a governor. And his lawyer didn't hold back either, calling it classic trademark bullying, and she said they can't own the name Ken outside of toys. In other reports I read, trademark attorney Brad Rose backed that up, and he told reporters that Mattel's claim is weak because the podcast and the toys are, quote, vastly different types of goods and audiences. Now, this isn't Mattel's first espresso. They've spent decades aggressively defending their intellectual property, even when it makes them look like the villain in their own story. In 1997, the Danish-Norwegian pop group Aqua released Barbie Girl with the immortal opening line, "I'm a Barbie girl in a Barbie world." Mattel lost its plastic mind. They filed a lawsuit in 2000 against MCA Records, which was Aqua's U.S. distributor, claiming trademark infringement and dilution of their Barbie brand. And they argued that the song tarnished Barbie's wholesome image. MCA Records didn't back down, and their defense, First Amendment parody. The case went to the Ninth Circuit Court of Appeals in 2002, and the judges sided with MCA, and they ruled that the song was protected as a parody/satire under free speech. The judge literally told them, quote, "The parties are advised to chill." So Mattel didn't win that one, but in a twist of irony, years later, they actually leaned into it. By the 2010s, and especially around the 2023 Barbie movie, Mattel embraced Barbie Girl and had it remixed into Barbie World for the film soundtrack. Now, they also filed an opposition against Burberry, who wanted to use the acronym BRBY as a mark. And they filed the opposition saying that it sounded too much like Barbie. And Burberry eventually just completely abandoned that application, so it didn't go anywhere from that. So yeah, that's basically Mattel's track record on trademarks. So right now, the case is in what is called the discovery phase. And both sides are digging into the documents and prepping arguments, and then maybe, or just hoping maybe, the other side will blink first. If it doesn't settle, then it then goes to a panel of administrative judges at the Trademark Trial and Appeal Board, and they will decide whether Ken can keep his name or if Mattel has to protect us all from mistaking him for a 6-inch figurine. All right, so here is what the TTAB will consider when they're making their decision. Could consumers be confused between the two? Are the products or services similar? Is Ken a strong, famous trademark? So, in my opinion, Ken is clearly a strong and famous trademark, but are the products and services similar? No, not in my opinion. Could consumers be confused between the two? In no world could I imagine that those two would be confused. Okay, so basically there's no ruling on this yet. And let's get real. This is like a doll versus a podcast. They have entirely different audiences, formats, distribution channels. I feel like this is one of those Streisand effects, like people might not have paid any attention to this at all, but because they've said something on it, now they've put this spotlight on it. And I really just can't see a connection at all. All right, this is all I've got for this video. This has been True Court Tales. Thank you for watching, and court is adjourned.